over conflict resolution and for acquiescence over accountability. So the first of the items I want to point out is that the international community has accepted that it bears a special responsibility for supervising the conflict and bringing it to a just and durable conclusion. Kofi Annan, the former Secretary General of the United Nations, stated in his memoirs, and here I quote, "As I told the Security Council before I left office in 2006, the Israeli-Palestinian conflict is not simply one unresolved problem among many. No other issue carries with it such a powerful symbolic and emotional charge affecting people far from the zone of conflict," unquote. After all, it has been the United Nations which voted to partition Palestine and enable the creation of the state of Israel. It was the United Nations that cared for millions of Palestinian refugees for 7 decades. It was the United Nations that has established multiple peacekeeping missions and has closely monitored the ongoing conflict through the regular issuance of resolutions and reports. The international community has been intimately engaged in the conflict through numerous diplomatic initiatives, massive arms sales, and significant quantities of aid, trade, grants, and investment. Whenever the conflict between Israelis and Arabs over the Palestine question has reached an acute stage, it has been the United Nations that has served as a diplomatic cockpit to manage the violence. The conflict has, in many ways, become the most international of international conflicts and will almost certainly remain at or near the top of the world's political agenda until a just and durable solution can be found. Second, the conflict between Israel and Palestine is a highly unequal struggle. Militarily, Israel possesses the strongest armed forces in the region, with nuclear weapons, a highly successful military-industrial complex, state-of-the-art weaponry, and a deeply integrated armed forces relationship with the United States, while the Palestinians have lightly armed police and security forces in the West Bank and low-grade rockets in Gaza. Economically, Israel enjoys a European-level standard of living with a gross national product in 2018 of over almost $41,000 American. That is 11 times higher than the Palestinian standard of $3,700 American. Diplomatically, Israel can count on the enduring support of the world's sole remaining superpower, as well as the more benign support of the European Union, all of which tends to count for far more in international relations than the large voting majorities, predominantly from the developing world, backing the Palestinians in the UN General Assembly. Territorially, Israel is the overwhelmingly dominant political power between the Mediterranean Sea and the Jordan River, with the Palestinians possessing only municipal-like authority within confined and fragmented patches of land. Demographically, the population of Israeli Jews and Palestinian Arabs in Israel and the Palestinian territory has reached a rough parity of approximately 6.5 million each, which serves to highlight the stark differences in democratic rights and social power. Taken together, the consequence of this highly asymmetrical relationship has been a sophisticated regime of control shaped by subjugation, a coercive environment, and the absence of rights. Third, the international community has established a detailed framework for the administration and resolution of the Israeli-Palestinian conflict anchored in international law, which enjoys broad acceptance. As Kofi Annan stated in 2002, and I quote again, "There is no conflict in the world today whose solution is so clear, so widely agreed upon, and so necessary to world peace as the Israeli-Palestinian conflict," unquote. The source of this framework is found in the hundreds of resolutions adopted by the leading organs of the United Nations, the Security Council, the General Assembly, and the Human Rights Council and its predecessor, that have overseen the conflict. Accordingly, the prolonged Israeli occupation must fully end, according to these resolutions. Both the Palestinians and Israelis are entitled to live in peace and security and to the right of self-determination, including secure, sovereign, and viable states within the boundaries of Mandate Palestine. The 250 Israeli settlements in East Jerusalem and the West Bank are deemed to be a flagrant violation under international law. East Jerusalem has been illegally annexed by Israel and remains occupied territory. The Palestinian refugees from the 1948 and 1967 wars have the right to choose to return to their homeland. Gaza is an integral part of Palestine. It remains occupied, and the Israeli blockade is a prohibited form of collective punishment. The importance of employing international law in conflict resolution involving two unequal parties is that it reduces the power imbalance between them, and it helps to ensure that the final resolution of any conflict is shaped by recognized rights and freedoms rather than by might, thereby offering the best chance for a sustainable peace. My fourth point is that Israel, with the frequent support of the United States, has been able to successfully insist since the start of the Madrid-Oslo peace process 30 years ago that any negotiations with the Palestinians are to be conducted outside of the framework of applicable international law and prevailing international consensus, notwithstanding the imperatives of the rules-based international order. This has enabled Israel to maintain an obdurate bargaining stance with the end game of securing its claims to East Jerusalem and to most, if not all, of its West Bank settlements, while tolerating a Potemkin statelet for the Palestinians with no meaningful space or sovereignty. The result has been a troubling paradox. While there is no conflict in the world where the United Nations has pronounced with such frequency and detail on the framework of international law for conflict resolution, this framework has rarely informed the various Oslo-related peace plans that have successively collapsed in the absence of any sturdy legal scaffolding to sustain a rights-based resolution. At its heart, this conflict is not a quarrel between intractable neighbors, a clash between involving ancient hatreds, or an irreconcilable struggle rooted in religion or ethnicity. It is rather a conflict over the denial of fundamental collective and individual human rights marked by the domination of one people over another, and its solution lies in the realization and protection of these fundamental rights for both Palestinians and Israelis. Changing course and interpreting the agreements between Israel and Palestine and the international statements on the conflict through the fundamental requirements of our rules-based international order, as international law requires, would finally ensure that rights, rather than realpolitik, govern the process to regulate and fully end the protracted occupation. My fifth point is that in recent years, the Israeli occupation has been metastasizing into something far harsher and more virulent, the permanent alien rule of one people over another, encased in an entrenched two-tier system of unequal rights and laws, segregated communities, separate networks of roads, and the asymmetrical access to property, social and employment rights based entirely on nationality and ethnicity. Legal scholars, including Israeli academics, have pointed out that under international law, an occupation must be short-term and temporary. It must be strictly conducted in the best interests of the population under occupation. It must be returned in its entirety to the sovereign, that is the people under occupation, as soon as reasonably possible. And the occupying power acquires absolutely no right to annex any part of the occupied territory. Yet the international legal framework on occupation has been increasingly unable to regulate, let alone effectively terminate, the momentous changes that Israel is generating on the ground. An occupying power that actively facilitates and protects the settlement of 700,000 of its civilians in occupied territory is engaged in de facto annexation and with no other intention but to keep the conquered land in perpetuity. Israeli Prime Minister Benjamin Netanyahu has stated that he's prepared to give the Palestinians only a state minus, while annexing significant parts of the West Bank and maintaining permanent security control over all of the land between the Mediterranean and the Jordan River. Some human rights organizations have called this process an annexation, a brand new contribution to the grammar of law. Others, including human rights experts from the United Nations and a prominent Israeli civil society body has said that the occupation is curdling into 21st century apartheid. My sixth point is that the decisive factor missing throughout both the 5-decade-long occupation and the longer conflict anchored in decisive events earlier in the 20th century has been the unwillingness of the international community to impose accountability. Under the Charter of the United Nations, every member of the United Nations agrees, and I'm quoting, to accept and carry out the decisions of the Security Council in accordance with the present charter, unquote. Yet, in the face of scores of Security Council and General Assembly resolutions affirming the principles of international law applicable to the occupation, Israel has remained adamantly resistant to international direction. When encountering a defiant state, the international community has created for itself a substantial menu of legal tools to challenge such insubordination and bring the recalcitrant state back within the rules-based international order. These obligations are anchored in the international duties found in the Fourth Geneva Convention of 1949 governing occupations and in the international law on state responsibility. And in terms of countermeasures, the International Committee of the Red Cross has laid out a wide range of effective remedial tools, including the imposition of visas for travel, a complete ban on the importation of settlement products, the downgrading or ending of diplomatic relations, the freezing of treaty relations, the withdrawal of political membership, the curbing of arms sales, and the imposition of economic sanctions, all of these which can be proportionally applied to bring about the restoration of legal and political compliance. Israel has been shrewd in its assessment that the international community, particularly the United States, the European Union, and the members of the Western Alliance, have lacked the political will to insist that it comply with its international obligations. As a result, it has rarely faced meaningful consequences for its truculent behavior. As the Israeli journalist Gideon Levy has written, and I'm quoting, "No country is as dependent on the support of the international community as Israel, yet Israel allows itself to defy the world as few do," unquote. And my seventh and final point is that among the targets of the growing illiberalism in Israel and the deep divisions within Palestinian society are the civil society organizations who regularly raise uncomfortable truths about the profoundly corrosive impact that the protracted occupation has had on human rights, democratic values, and the rule of law. Both Israel and Palestine have active human rights organizations that have produced groundbreaking reports and conduct influential advocacy campaigns internationally on the bleak rights record of the Israeli occupation, as well, increasingly, on the pattern of human rights breaches by the Palestinian Authority and Hamas. Within Palestinian society, organizations such as Al-Haq, Adamir, El-Mizan, the Palestinian Center for Human Rights, the Society of St. Ives, and the Jerusalem Legal Aid and Human Rights Center dispassionately depict the yawning gap between international legal standards and the systematic violations of human rights and humanitarian law committed by Israel in its conduct of the occupation. On the Israeli side, organizations such as B'Tselem, Gisha, Adela, Yashtin, Iyarmern, Breaking the Silence, Amochad, and the Association for Civil Rights in Israel do the same within their society. Together, these groups speak a common language grounded in the core documents of the international human rights and humanitarian law, and they persist in their intrepid activism to investigate the regime of human rights violations that is integral to the occupation. Yet all of them are facing a shrinking space to criticize the disfigured state of human rights under occupation, as they become the prime targets of those who are intolerant of their criticism, yet alarmed by their effectiveness. Very few of these dominant attributes of the conflict have found a place in the shaping of recent Canadian policy towards the Israeli occupation of Palestine. At the United Nations, Canada voted against or abstained on every resolution dealing with the Israeli occupation at the UN General Assembly beginning in 2011 until it has cast 2 solitary votes in favor of Palestinian self-determination in December 2019 and December 2020. In doing so, Canada has argued that these resolutions are unbalanced and unfairly single out Israel, while disregarding the fact that these resolutions reflect the international legal framework applicable to the conflict, which Canada has formally endorsed, and that they are focused not on Israel per se, but on its protracted occupation of Palestine. In the Canadian courts, when the Canadian Food Inspection Agency in 2017 reversed this position and held that wines from the Israeli settlements could be labeled as product of Israel in Canadian liquor stores, the Canadian government defended the ruling of the agency at the Federal Court of Canada. When the court subsequently ruled in the case known as Kattenberg, and I want to acknowledge that David Kattenberg himself is actually on this call today, when the court subsequently ruled in Kattenberg that this labeling of settlement products was false, misleading, and deceptive, the Canadian government appealed the decision. Regarding our relationship with the Trump administration, much of the world criticized the American Peace to Prosperity Plan following its release in January 2020. The criticism focused on the plan's proposal to give Israel a green light to illegally annex substantial portions of the West Bank while offering the Palestinians a moth-eaten statelet. The European Union said that the Trump plan broke with internationally agreed parameters, while Pope Francis warned about the danger of inequitable solutions. Canada, in contrast, issued a vanilla statement promising to, and here I'm quoting, carefully examine the details of the US initiative for the Middle East peace process, unquote. And respecting the complaints filed at the International Criminal Court respecting war crimes and crimes against humanity committed in the occupied Palestinian territory, which I referred to at the beginning of my presentation, Israeli Prime Minister Benjamin Netanyahu asked Canada to intervene in the proceedings after the chief prosecutor had determined in December 2019 that there was a reasonable basis on the evidence to proceed to a formal investigation stage. Canada subsequently wrote to the International Criminal Court to oppose Palestine's status as a state signatory to the Rome Statute to bring its complaints, while at the same breath reminding the International Criminal Court of Canada's financial contributions to its operations. Now, a realist might say that Canada has never been more than a secondary player in the resolution of the Israeli occupation of Palestine. The Canadian government possesses none of the formidable military, diplomatic, and economic weight that the United States deploys to shield Israel, and Canada lacks Europe's extensive trading relationship with Israel. Nor has Canada demonstrated much sensitivity about the colonial predicament of the Palestinians. Yet, as Canada aspires to punch above its weight, such a middle power could seek to narrow as much as possible the gap between international law and the observation of rights on the ground. International law is the spine of the international system, and when used imaginatively, it can purposefully shape the political dynamics necessary to reach successful conflict resolutions. As Daniel Levy, a former peace process negotiator for Israel, has stated respecting the Israeli occupation, and here I quote, "Human rights and international legality should be our guiding star and no longer be subordinate to maintaining a peace process that has so palpably failed to deliver." From the 1980s to the mid-2000s, Canada stayed close to Israel while following the international consensus by voting against some Israeli practices in the occupied territories at the United Nations, expanding its funding of social programs for the Palestinians, and becoming involved in the Oslo peace process as the chair of the multilateral Committee on the Palestinian Refugees. Canada has always trailed behind other middle powers in acknowledging the orphan political status of the Palestinians, but its willingness to cautiously distance itself during the Chrétien government from the excesses of American foreign policy and Israeli conduct gave it some diplomatic cachet in the contemporary Middle East and beyond. This cachet steadily evaporated during the Stephen Harper years, and it has been slow to return during the first 5 years of Justin Trudeau's time in power. To its credit, The Trudeau government did restore Canada's funding cuts imposed by Stephen Harper to the United Nations Relief and Works Agency, UNRWA, which supports Palestinian refugees in the Middle East. As well, it softened Canada's tone towards Israel and Palestine after the bellicosity of the Harper years, but the needle did not move far. Both Trudeau and Harper campaigned for a UN Security Council seat, and both lost, in part because of Canada's continuing support for a nationalistic Israeli government whose evisceration of the last flickering embers of a two-state solution has become increasingly unpopular throughout much of the world. The Trudeau government's thin record on the Israeli occupation and its great reluctance in 2020 to publicly oppose Israel's annexation plans became a diplomatic albatross during its Security Council campaign, which a letter written just prior to the Security Council vote in June 2020 by the Canadian ambassador to the UN to other Canadian ambassadors attempting to justify its positions on Palestine and the occupation could not overcome. This late in the day letter would not have been written if Canada did not perceive that its policies towards Israel and Palestine were becoming a significant liability in the eyes of many in the international community. Canada lost its Security Council bid to two small European countries, Ireland and Norway, that lacked Canada's stature as a member of the G7, the G20, and the Trans-Pacific Partnership, but whose strengths included a much more principled position on the Israeli occupation of Palestine. A foreign policy grounded in human rights and international law, democracy, and a rules-based international order, as the Canadian government aspires to, is ultimately tested not by the eloquence of its proclamations, but by the gritty amelioration of the human condition that it seeks to transform. Indeed, the question of Palestine has become a daunting litmus test for the efficacy of Canada's foreign policy. A middle power which identifies with a rules-based international order would have long ago concluded that Israel was insincere in seeking to end its interminable occupation. It would have drawn the necessary lessons from Israel's ardent refusal to accept the application of the Fourth Geneva Convention, the many unfulfilled Security Council and General Assembly resolutions, and the innumerable facts on the ground. Such a middle power would have recognized the grossly asymmetrical balance of power on the ground, and it would have sought to reward not the occupying power that has annexation in its sights, but to instead aid the subjugated population whose quest for freedom on its own land has been perpetually thwarted. It would have concluded that the Israeli leadership will not alter its defiant course unless and until the international community, acting in common, imposes an escalating economic and political cost on Israel for the occupation's continuation. Only a foreign policy anchored in the realism of these irreducible facts can hope to match the aspirational reach of its stated commitments. Let me end there, at least the formal part of my presentation, by saying to you something I say regularly when I speak to the United Nations. This occupation will not die of old age. International law is the one common language that we all share in the modern world and that we've all committed ourselves to, whether or not we take it seriously or not. It's the language, it's the tool we can use to hold up a mirror to others and saying, you're not complying with what you've agreed to. In his very last speech on the 3rd of April, 1968, the so-called mountaintop speech, Martin Luther King said, with respect to America, all we ask is that you do what you said you're going to do on paper. In other words, you fulfill the promises of equality in the American Constitution. I say the same thing with respect to international law. The international community, virtually every member of the international community, including the United States, has committed itself over and over again through Security Council and General Assembly and Human Rights Council resolutions to apply the precepts of international law, including the fact that an occupying power has no right to claim any sovereignty over even a square inch of occupied territory. When you think of the modern occupations in this world, the American occupation of Japan ended after 10 years. The Western powers' occupation of Western Germany ended after roughly 10 years. The American occupation of Iraq ended after roughly 9 to 10 years. Yet here we have a 53-year-old, almost 54-year-old occupation where there's been over 700,000 Israeli citizens placed into settlements in occupied territory, which have been condemned since virtually the very beginning of the occupation, of which there is no sign that the occupying power pays any heed to the demands of the Security Council, the Human Rights Council, and the General Assembly to heed these resolutions. Nothing could be more taken in bad faith than the fact that Israel can ignore all of these resolutions and continue along, where the United States will vote in favor, had voted in the past in favor of these resolutions, but offers the necessary diplomatic cover for Israel to continue its occupation. Just let me end there. I think I've given you an overview for a general audience with respect to what I think are the failures of the leading political organs of the United Nations, the Security Council and the General Assembly, to bring this occupation to an end. Criticism without consequences has no meaning in the modern world. And when you think that the international community has an extensive menu to bring occupations like this to an end, or gross human rights violations to an end, it shows you the gap between promise and performance.
Thank you, Michael. Thank you very much. It was extremely informative. Just kind of overwhelmed by it. Okay, I do have a variety of questions that have come in. So again, I would ask everyone to keep your microphones on mute, and then we'll proceed. So I'm going to ask the questions now. I'll start with them. The first one is, are Palestinians on the ground reaching a consensus on what kind of state they want? 2-state, 1-state, or something else?
Okay. It's probably better off to ask a Palestinian that. I'm a distant observer in many ways, but I do know that polling continually shows that there's a slippage in support for a 2-state solution and a rise in support for a 1-state solution. I don't think there's a plurality yet, but certainly the recent opinion polls taken among Palestinians points in that direction. And what is probably noticeable with respect to this polling is it's showing a stronger and stronger support among younger Palestinians for a 1-state solution. And this is in spite of the fact there's no leading political organ in Palestine that supports a 1-state solution. But I'm going to leave it as brief as that, because I think it's probably better asked to a Palestinian.
Okay, thank you. The next question, what specific concerted actions do we need to engage in with the Canadian government to help fulfill the aspirations of the Palestinian people?
Oh boy, we've only got another 45 minutes left in this. Canada is if I said it mildly, is behind the curve with respect to it's behind the arc of history. And when I deal often in my role as Special Rapporteur with European civil society organizations that deal in human rights, and in particular with respect to the Israeli-Palestinian conflict. And they are often complaining to me about how much more work they've got to do to move the Dutch government or the Belgian government or the Norwegian government or the German government on issues like this. I often say quietly to myself, gosh, I wish we in Canada had your problems. We have a government which is which I don't recall ever raising a criticism of Israel in recent years, certainly in the period, and this is a very telling, I think, litmus test, in the period between the announcement of the Trump Peace to Prosperity Plan in late January 2020, which would have covered Israeli annexation of at least a third of the West Bank and certainly all of East Jerusalem. to the point in time where annexation was taken off the table in August of 2020. There was not one single official Canadian statement that I'm aware of where Canada criticized Israel or urged it not to go forward with annexation or proclaimed that annexation was a violation of international law. The only statement I'm aware of rose as a result of a letter signed by 50 former Canadian diplomats urging Canada to take a strong public stance against annexation, and then questions being put to Pierre Trudeau, shows my age, Justin Trudeau, at a press conference in early June 2020. He had several days before had a telephone conversation with Benjamin Netanyahu, and in the press release after the telephone conversation issued by the Prime Minister's office, there was no mention that he raised any critical remarks to Benjamin Netanyahu with respect to annexation. So Canada has probably taken the path of least, if I can put least to the 20th degree, least resistance with respect to this. I have, if you want to use myself, which I don't like doing, but I have much easier access to speaking to leading foreign affairs diplomats and political leaders in Europe than I do trying to speak to people at Global Affairs Canada. So that may tell you something with respect to where Canada stands on all of this.
Thank you. Next question. I understand that Karim Khan has been elected as ICC prosecutor to succeed Fatou Bensouda. I'm wondering whether Mr. Lynk has knowledge of Karim Khan and any opinion on the appointment's impact on the likelihood that the ICC case will proceed.
Very good question. The current prosecutor of the International Criminal Court, Fatima Bensouda, her 9-year term ends, I believe, on the 15th or 16th of June, 2021. And it is she who has brought forward the various complaints with respect to alleged war crimes and crimes against humanity committed in the occupied Palestinian territory beginning in June of 2014 onward. She's been replaced about a week ago. She will be replaced in June by Mr. Karim Khan, who's a very distinguished British barrister who has a lot of experience in front of the International Criminal Court and with respect to international criminal law. I think it's far too soon to judge where he may stand with respect to the Israel-Palestine file. I take it at people's word who do know him, who've talked to me about him, that he is extremely skilled, experienced, and knowledgeable lawyer in international criminal law. And I take it on face value that he will come into the job respecting the impartiality and independence of the prosecutor's position. Having said that, we all know that the International Criminal Court is subject to extraordinary political headwinds, which was evidenced by the move in 2020 by the United States government to forbid any International Criminal Court officials, including Madam Bensouda, from being in the United States. It's always struck me as odd that the US, which was a world leader in the creation of modern international law, would actually take a stance to try to punish a prosecutor of an impartial court, rather than going after the alleged violators of international criminal law. But so that's the most that I can offer with respect to Mr. Khan. I am hopeful, I am optimistic, unless and until I see evidence otherwise with respect to this.
Thank you. Can you elaborate on the current conditions of the pandemic in the occupied Palestinian territories and what is now widely known as the Israeli medical apartheid?
Sure. Very briefly, the death rate has gone, I think, is either at or about 2,000 Palestinians having died, and well over 100,000 people having been infected. I don't have the most recent figures here in front of me, but I do know that there's been, the Palestinians had initially attempted to try to find outside sources, probably I believe in India, China, and Russia, for the supply of vaccinations to come to the territories. But even on the most optimistic scale, it was clear that the Palestinians were not going to get vaccinations en masse for many, many weeks. And there still isn't any expectation that it's going to be a large-scale delivery of COVID-19 vaccinations, at least till the end of March and quite possibly later. Part of the issue has to do with funding. The Palestinians have to rely upon external aid in order to be able to pay for the vaccinations. Part of it has to do with that not a single item ever enters into Palestinian territory, and particularly the West Bank, without the approval of Israel. And it has to negotiate with Israel over all of the delivery of healthcare equipment and medicines for Gaza and for the West Bank. And the interesting thing is that while Israel is going through a rapid vaccination program, Palestinian workers are allowed to continue to come in on a daily basis into Israel, even though they're not vaccinated. The same thing is true with respect to Palestinian workers working in the Israeli settlements on construction or manual labor jobs. There is that they have no access to vaccination. So in some ways, it's Israel cutting off its nose in spite of its face. In that it is not, if it's going to live cheek and jowl with the Palestinians, despite the significant efforts towards segregation of populations, they are inevitably going to be intermingling, and you allow intermingling with people who do not have access to vaccination, you're only worsening the conditions for the spread of the disease among yourself.
Thank you. I'm checking our time. We still have time. Okay. Can you talk about the destruction of the nature reserve in Tubas? What I haven't seen mentioned is that the IDF chose to perpetrate this destruction of trees on Tu B'Shavat, the Jewish New Year's for trees, sort of Jewish Earth Day. The optics are astounding.
Look, I have a general knowledge of that, and I comment generally on that. It sounds like the questioner may have more specific knowledge than I do with respect to this. But more generally, the issue of creating nature reserves is in the occupied territories is one form of land alienation from the Palestinians. It goes together with military firing zones and the alienation of both public and private Palestinian land for the creation or expansion of settlements. It is, the common phrase used by leading Israeli politicians is maximum land for Israel, minimum land for Palestinians, and the impact of creating more nature reserves, more military firing zones, more settlements is the scarcity of land available and remaining for Palestinians to be able to live in. And if this is not a denial of self-determination, then certainly nothing is. Keep in mind that the International Bill of Rights is made up of three documents: the 1948 Universal Declaration of Human Rights and the two 1966 International Covenants on Human Rights. Common Article number 1 for each of the two 1966 international covenants is the right of self-determination. And the world put the self-determination first in both of those international covenants because it believed that no other rights are possible to be realized unless a people has self-determination first to be able to have the social and economic and governmental institutions to put those rights, all the other rights, into action. So if you don't have the right to self-determination, if the actions of your occupying power, in this case, your alien ruler, are intended to try to deny you having the land base, the territorial territory for being able to use that as your basis for self-determination, then you have no other affirmed right that you can have securely attached to you.
Thank you. The next question, how do we reverse Canada's BDS position?
It probably remains to be seen what happens with Canada's BDS position. The federal government has stated that it's a policy as part of its anti-racism program. The Ontario government has passed the International Holocaust Remembrance Alliance definition as part of its, as an order in council. By themselves, simply stating that a BDS definition or a BDS policy or a adoption of the International Holocaust Remembrance Association Alliance definition is part of government policy is not law, and it remains to be seen whether that's going to be put into law. If it actually was put into legislation either federally or provincially, then I think there's probably a solid ground for bringing a charter challenge on the basis of it's a violation of freedom of speech. My own view, I look at the International Holocaust Remembrance Alliance definition on anti-Semitism. The principles themselves are supportable. I don't have a problem with them. It's the examples that are used to illustrate the principles that I think it runs into much more troublesome territory. Because 7 of the 11 examples have to do with criticism involving Israel. And I think, I think we can separate some criticism of Israel with respect to anti-Semitism with respect to Jews. And, it's important, and I always want to say this, our very first goal as human rights activists when it comes to anti-Semitism is to oppose it, no matter where it is, no matter who spurts it. Anti-Semitism is vile, and it's a fundamental breach of any modern definition of human rights. But on the other hand, we also have to make sure that anti-Semitism doesn't become weaponized in order to try to block or diminish or dampen legitimate criticism of Israel. And as I've said to you with respect to my brief review of human rights in the occupied Palestinian territory, there is plenty to criticize Israel and its conduct of the occupation. My mandate only goes to the occupied Palestinian territory. And so when I hear that a resolution supporting Palestinian self-determination is adopted by Canada, and then Canada is criticized for taking an adopting or supporting an anti-Israel position at the United Nations, my eyes roll backward. The resolution on Palestinian self-determination is self-determination on the occupied Palestinian territory, is not against Israel per se. It is against Israeli occupation policies in the occupied Palestinian territory.
Thank you. Next question. Any attempts to criticize the Israeli state for its actions are flagged as anti-Semitic and are now, under some Canadian legislation, to be prosecuted as hate speech. How do average Canadians engage in meaningful dialogue within our communities in order to expand awareness for the reality of the Palestinian situation on the ground without running into the shouts of anti-Semitism?
Okay, just to be clear, and this is obviously an echo of what I said a few minutes ago, I'm not aware of any BDS, anti-BDS legislation being passed in Canada. I'm not aware that the International Holocaust Remembrance Alliance definition of anti-Semitism is passed into legislation in Canada. It has been adopted by policy and is adopted as an order in council in Ontario, but that doesn't mean it's part of legislation. If the Ontario government began to act upon its order in council with respect to the definition, and actually withheld funding from a group, for example, or took actions against an organization because it was critical of Israeli occupation, then I think that's ample grounds for violation of our charter rights under Section 2B of the Charter of Rights and Freedoms from 1982. And I think that's probably what's been why there's been a caution both at the federal level and the Ontario level, why it hasn't moved into become legislation. Now, one thing I worry about is that there are some organizations which are urging governments to define funding for civil society organizations based on whether or not they adopt the IHRA definition. And basically saying if you are funding organizations and they don't adopt the IHRA definition, then you should, as a matter of state policy, withhold funding from them. And again, I think that's worrisome. And I think, again, that would probably engage the charter. And I would think that a compelling case could be put to a court that the government's actually acting on the IHRA definition in particular. It's not so much the definition that, as I said, I'm concerned about, as the examples that it uses with respect to criticism of Israel would in fact be violations of the Canadian Charter. Certainly there has been case law in the United States where I believe over 25 states have adopted definition and insist upon any contract that is signed by a contractor with a state includes a pledge not to boycott Israel, that those anti-boycott provisions have been struck down in a range of cases in the American courts. It hasn't gone to the U.S. Supreme Court yet, but I would think our robust support for free speech and free expression in Canada would wind up meaning many of those provisions would likely run into constitutional issues.
Thank you. The next question, is it worth pushing Canadian opposition parties, especially the NDP, to take a better stance? Currently, 2 NDP MPs chair or sit on the Israeli Parliamentary Friendship Committee.
Well, I mean, that's, I'm aware that there's a spectrum of views with respect to the Canadian politics on Israel and Palestine. I'm aware that people who lobby and advocate for Palestinian rights are likely to find a home for probably their best homes either in the Green Party or in the New Democratic Party. I think all parties should be written to. I mean, you're asking me what should be done in Canada. I would probably rely upon the traditional means of advocacy. Write letters to the editor, write letters to your MP, meet with your MP in force as church groups or civil society organizations or as trade unions, and push upon them the fact that the Canadian policy actually has stated by on the website of Global Affairs Canada is actually very compelling. It says that it supports use of international law in regulating the occupation. It says that the Fourth Geneva Convention applies. It says that the Israeli settlements are in breach of the Fourth Geneva Convention. It supports, it says that it won't recognize any annexation by Israel unless and until there's a final agreement by all of the parties ending the conflict. The Canadian stated policy is actually quite good. If only the Canadian government would wind up following Canadian policy with respect to this. If it did actually robustly apply its stated policy, it would be much more critical in public and in private with respect to Israeli conduct on this.
Thank you. Next question. Jeff Happer has argued powerfully that ending the occupation is not enough, but that Palestinians need an explicit plan for what comes next, the structures of what comes next, and how to get there. Please comment.
I guess all I can say is this. Let me put it this way. There are 4 choices and 4 choices only in front of the parties with respect to what the future will have. One is a 2-state solution, a genuine 2-state solution where the Palestinians form a democratic, sovereign, durable state on the occupied Palestinian territory of East Jerusalem, the West Bank, and Gaza. Second possibility of a resolution of this conflict is a genuine 1-state solution, which means that Palestinians and Israelis between the Jordan and the Mediterranean form a state on the territory of Mandate Palestine, and all have equal voting, political, legal, social, economic rights. There are many forms in which you can wind up negotiating a compromise with respect to that, but essentially it'd be some kind of 1-state solution. The third option would be a 1-state apartheid or 1-state reality of unequal rights, which means that basically what the Trump annexation plan would have proposed, where Israel gets to annex another 30% of the West Bank, it holds on to East Jerusalem, and the Palestinians have a rump statelet that is a state minus in what remains of the West Bank, which would be essentially the Palestinian cities and major towns, and the Gaza Strip, which Israel doesn't want. So that is option number 3. And option number 4 is that nothing changes. It continues on as before with de facto annexation steadily moving forward. Those are the 4 options. There are no others. The first 2 I can wind up supporting as someone who works in international law, is that as long as there is a working relationship, a constitution, a political structures that guarantee equal rights to Palestinians and Israelis, either in 2 states or in 1 state, then that strikes me as being consistent with the modern-based rules-based international order. Options 3 and 4 are profoundly contrary to human rights and to international law and should be opposed. And that's, I guess, the way I'd put forth where we might be going with respect to solutions.
Thank you. Does Canada have the equivalent of the USA Leahy rule or law that foreign aid is contingent on compliance with support of human rights?
That's a good question. I don't know enough about Canadian law. I know that there have been policies and programs that have said that we use human rights as an important filter for assessing both our foreign policy in general and the distribution of foreign aid in particular. I don't know if it's a statutory requirement. I'd be frankly surprised at that, but I'm sure it's probably stated government policy, which allows them much more flexibility in the determining when it would actually move on this. I know of no instance, though, in recent years where the Canadian government has said there are profound human rights violations taking place in the occupied Palestinian territory, and therefore we're going to review our trade agreements or our cultural agreements or scientific agreements with Israel because we think that it is in violation of some fundamental human rights precepts. I'm aware of it never of any instance where it's actually taken that step.
Thank you. Question that was, there were several questions about specific steps that you would recommend we take to engage with the Canadian government to help fulfill the aspirations of the Palestinian people. And I think you've addressed that very well. One came up that said, what do you think is the best way to get the international community to be tougher on Israel?
Excellent question, and one that I puzzle with a lot on this. Besides naming and shaming or pointing out in my own reports and my own public statements the vast yawning gap between performance and promise and performance with respect to the ongoing occupation. I essentially rest my hopes in a couple of areas. One is in civil society organizations. I look at particular how vibrant, how robust, how active they are in many European capitals, particularly in Central and Western Europe. And I think of countries that have fairly progressive stances with respect to Israel and Palestine. I think of the Belgians or the Norways or the Irelands of the world. And that's in some ways quite consistent with having a robust civil society where church groups, trade unions, and ordinary human rights groups do a lot of concerted work to try to ensure that issues involving Israel and Palestine are foremost in the government's policymaking towards the Middle East. And they've been largely successful in moving the needle on their government's foreign policy. One example is how close Ireland came to adopting an occupied territories bill, which would have been legislation stating that it would be a criminal offense for any business or organization to import into Ireland goods coming from Israeli settlements. And I think that's a very strong symbolic piece to be able for civil society groups to organize around to push their governments on this. As you know, if Ireland is at one end of the spectrum on this, and that occupied territories bill is actually in abeyance now because it's not part of the current Irish coalition government's common mandate. But the Irish civil society has said they're not going to give up on that. If that's one end of the spectrum, then we in Canada have to be at the other end of the spectrum, given that we refreshed, renewed, and updated the Canada-Israel Free Trade Agreement in 2019, where we continued explicit application of the Canada-Israel Free Trade Agreement, allowing Israeli goods to enter into the Canadian marketplace tariff-free, where we allowed that to be for Israeli settlement goods. You know, first of all, settlement goods should not be coming in tariff-free. Second of all, I say Israeli settlement goods should not be coming in, period, into the international market. If the international community, through at least 6 Security Council resolutions, has said that the Israeli settlements are, and I quote, a flagrant violation under international law, and if under Canadian law, the moving by an occupying power of its civilian population into occupied territory is actually a war crime under both the Rome Statute of 1998 and under Canadian law. We adopted that law in 2000 into our own criminal code. How is it that if these are war crimes, that we are actually saying blithely, these goods should continue to come into Canada? If Canada was to actually act upon what its own laws compel it to do, we would be sending, I think, important moral and political lesson to the rest of the world. I wish we were there, but we're at the other end of the spectrum with respect to this.
Thank you.
If people think I'm being a bit harsh on Canada, I always remember the comment by Ai Weiwei, who is the very famous Chinese artist who's now living in exile in Berlin. And his father was a renowned progressive poet who actually was put under house arrest and then exiled to the countryside during the Great Cultural Revolution in the 1960s in China. And his father once said, "It's your own country. You don't have to be polite."
Okay, that's a good point. Thank you. Another question that came in, and also I think there's every reason to be harsh on Canada because of its policies toward Israel and Palestine. It's my little 2 cents. Next question. In your analysis, do Palestinians have a right to use armed struggle?
Legally, they do. You know, I believe there were statements issued by the United Nations in the 1960s and 1970s during the great wave of anti-colonization, where it said that a people living under alien rule have the right to be able to take up arms against their oppressor, their colonizer, their occupier, and so on. Having said that, it strikes me as that the Palestinians are much the wiser. And here, you know, I'm not a Palestinian myself, but I say this as an outside observer. Palestinians are much the wiser for finding creative ways of civil disobedience and peaceful resistance to alien rule and the occupation. First of all, as I mentioned in my formal presentation, you know, Israel is the strongest military power in the region and one of the strongest military powers in the world. The Palestinians are lightly armed, even though there's a rough equivalence in population between the two, between the Mediterranean and the Jordan River. The Palestinians could never hope, I think, to be successful in any armed struggle. So and secondly, I just think it winds up creating much greater support worldwide if your struggle is seen to be peaceful, employing civil disobedience, and employing other means of creative resistance to an occupation. You're much more bound to be able to get support worldwide with respect to that than you are through any forms of armed struggle. Unfortunately, many aspects of Palestinian resistance as one of being targeted against Israeli civilians. And no matter how just your cause is, targeting civilians is always going to wind up being a war crime. And as well as that, it winds up being an own goal, as they say in soccer. It winds up diminishing the morality and justice of your own struggle in the eyes of the world.
Thank you. Wouldn't you say that until the U.S. condemns Israel and stops sending military armaments to Israel, that Israel will continue its illegal mistreatment of Palestinians?
Sorry, just repeat that again, please.
Wouldn't you say that until the U.S. condemns Israel and stops sending it military armaments, that Israel will continue its illegal mistreatment of the Palestinians?
Well, it's yes, the United States is an enormous factor with respect to this. If you look at Kofi Annan's memoirs, which I quoted earlier, he actually says that the primary cause for the continuation of the Israeli occupation and for the passive support for accountability by much of the Western world has been the United States' unhealthy possessiveness of the Middle East peace process. He actually says that in words. So the United States is a key factor in wanting to move them with respect to its almost unflinching support for the Israeli occupation. But it isn't only the United States either. You think of, I think of Europe, and I often cite Europe. 30 to 35% of all Israeli external trade is with the European community, the European Union. If Europe was able to use or was willing to use its extraordinary economic leverage with respect to this, then Israel would wind up moving as well. And I say this, also citing internal sources as well. Many liberal Israelis, many Israelis of conscience will say that nothing will change with respect to the Israeli political climate or the Israeli government's appetite for deepening the occupation and for extending de facto with the hope of having it de jure annexation, unless and until the world decisively changes its attitude and its approach towards Israel. Israel realizes that unless and until it pays any kind of cost for the occupation, it can continue to do what it wishes, despite criticism coming from the United Nations.
Thank you. Next question. Palestinians have mostly ceased violent opposition to the occupation, but their protests are ignored, and even the brutal Israeli response to the right of return march was largely ignored. What should the Palestinians do?
I agree, that much of the Palestinian resistance, certainly in recent years, has been nonviolent. That much of the Palestinian resistance is not remarked upon unless and until there is a bomb going off in a cafe or another car ramming. And it allows, I guess, the Israeli government's PR machine to continue that the Palestinians are violent and they're inherently violent. I do agree that a lot of Palestinian resistance is nonviolent, and it tends to be happen below the surface, that is not recognized in the world. And when it does happen, it's met with extraordinary violence coming back from the Israeli government, as witnessed through the 2018 Great March of Return, and the over 200 Palestinians who were shot dead by Israeli military power, and the thousands of Palestinians that were wounded. And this leads to, obviously, the ICC investigations. There are at least 3 separate areas where the International Criminal Court is open to investigating the Israeli conduct. One is the Israeli conduct during the 2014 war on Gaza. The second of the Israeli settlements, and the third is the Israeli shootings and massacres at the Gaza fence in 2018, 2019. So for all those deaths, all those needless deaths, which I think there's a potentially strong argument for that they do constitute a war crime and a crime against humanity under the Rome Statute. If there's anything good to come out of all of that, it would be that it has fueled the ICC investigations.
Thank you. We have a couple minutes left for questions. Are you aware of the Israel influence change to Canadian public educational resources to demonize Muslims in general and Palestinians as terrorists? The Institute for Curricular Service in USA has already affected 11,000 changes in US adopted K-12 textbooks.
I'm not. That's just not a question I know enough about to be able to answer, I'm afraid.
Okay, thank you. Someone said, do you have any contact with US influencers?
I have contact with plenty of Americans who work in this issue. I'm not sure how influential they are. Some are. I've done work with the Foundation for Middle East Peace. I hardly endorse their work, and they issue a daily issue of about 15 to 20 important stories on Israel and Palestine. And the service is for free. I highly recommend it. If you don't get it and you are interested in having a 5 to 10 minute summary of what the day's news is from reputable news sources such as Haaretz or the New York Times or from leading civil society reports, then I urge you to go to the Foundation for Middle East Peace website in Washington and put yourself down as a subscriber to their daily newsletter. It is truly a invaluable resource, and I can never really start my day without going through it.
Thank you again. We are just about out of time, so I would like to turn the remainder of the time over to Maisa, one of our board members, for some concluding remarks. Again, Michael, thank you very much on behalf of everybody who is here, and certainly for myself. It's very informative, very helpful, frustrating in many ways because it's hard to know where to move next, but I thank you very much for your time and your efforts and your work.
And thank you, Robert, for hosting this as well, and thank you for your kind words.
You're very welcome. Maisa?
Yeah, I would like to repeat again, thank you, Michael. It's been an honor to have you. Thank you for your generosity with time, answering all the questions. And I know many of the questions were kind of like not related to your mandate, but you were very generous and tried to answer most of the questions. I really appreciate that you shared with us these powerful and clear and sharp insights about the occupation, about the international community engagement, and diplomatic Canada's position with regards to the question of Palestine. I think it was very important to remind people about the significance of the right of self-determination, and also to understand that anti-Semitism should not stop us from criticizing the policies and practices of the Israeli government and the Israeli state. And I really appreciated how organized your talk was by bringing the 7 features that we need to remember every time we consider talking about the occupation and the struggle that is the struggle is unequal. The occupation is creating this framework of asymmetric power relation between the Palestinians and the Israelis. And also you reminded us that the international community has been engaged by issuing all these resolutions about the self-determination, the right of return, the illegality of annexation, the settlement, but at the same time, as Israel is supported by the US and with the lack engagement of major powers like Europe or mid powers like Canada, Israel is able to continue its non-compliance with international community directions, let me put it, as you put it in one of your articles. And again, I would like really to thank you particularly for the last point you ended your talk about, when you brought this lack of enforcement and how it's producing the lack of accountability. And I think this is very important for all our audience to remember and think about, and also encourage people to be more engaged in what you provided as a way to kind of like change the current by being involved in civil society organization either inside Palestine, Israel, or internationally. So thank you. And I would like to thank all our audience. I would like to talk about our next webinar, which will be on Saturday, April 17th at 11. We will share information with you, but we are really so grateful for Salwa Daibes and Gerard Horton, who accepted our invitation to come and talk to us about children in military detention in Israel. Salwa and Gerard are the co-founders of Military Court Watch. It's an organization that work on observing the situation for Palestinian children in Israeli prisons. So we will send you the information about this webinar. We would like to see you all there. From now till that time, stay safe, and thank you very much. Again, thank you, Michael.
And my pleasure. If I can just close by saying how pleased I was to be invited to this. And just to tell you something, when I first took this position almost 5 years ago, I was told by one of my predecessors that there's two qualities you have to have. And I say this not so much that I try to live by them, sometimes unsuccessfully, but I offer them to you for all of you who do work on this issue. The first thing was, he told me, you have to be fearless. You know, this means pushing boundaries. If you're going to oppose the occupation, you're going to upset a lot of people who support the occupation. And he said you have to be brave and exhibit courage, because you're going to get pushback with respect to this. But the second thing he told me was, you have to be responsible. You have to ensure that you're right on the law. You have to ensure that your facts are lined up well. You have to ensure that you line yourself with good NGOs who have reliable information. And so I put that onto you as well, that if you exhibit both fearlessness and responsibility in the work that you do on this issue or in other social justice issues that you're concerned about, then that will take you a large way towards the goal where you want to go. Thank you very much, everybody.
Thank you. Well said, Michael. Thank you very much.
Thank you.
Thank you. We'll see everybody hopefully next month at the next webinar. Goodbye.
Thank you. That was great. Take care.
Thank you.
Thanks so much.
Thank you.
Thank you so much.
Thank you from seminar.
Definitely.
Great information and encouragement.
That's right.
Feel very inspired again. Thank you.
Glad to hear it.
Blessings.